Number 98, People versus Daniel Talluto. Counsel, whenever you're ready.
Good afternoon. May it please the court, my name is Brad Keeman. I represent the defendant appellant, Mr. Talluto. I'd like to reserve 2 minutes for rebuttal.
You have 2 minutes.
When affirming Mr. Talluto's designation as a violent felony sex offender, the Fourth Department majority claimed that their hands were tied and called the results illogical and unfair. We assert, however, that when the application of a statute leads to an unreasonable or absurd result, it cannot be effectuated. Here, the absurdity is self-evident. Mr. Talluto, all the parties agree, was...
You agree it does read the way it reads?
I do, Your Honor. But here, it reads the way it reads, but all the parties agree he was convicted of a non-violent felony offense in Michigan. His designation in New York as a violent felony sex offender is then therefore contrary to logic.
But what should we make of the legislature changing the language in 2002, but keeping this language in?
I think that that language in 2002, keeping it in, it still didn't understand the ramifications of that change because it hadn't been brought up yet, really.
So is it our function to sort of foresee what they should have understood or didn't?
I don't think it's your function to foresee what they did or didn't, but what happened here is still an absurd or illogical result.
What do you make of the many requests to amend the statute? And I think several years' worth of proposed amendments to the statute that were never actually passed.
I agree that there have been several requests to do so, but still, even the court or the legislature's failure to act doesn't mean that this court can allow an unreasonable or absurd result to stand.
But doesn't that somehow indicate they don't think it's that unreasonable? If they did, they would fix it. They know how it's been interpreted now. So we're, in a sense, overriding the legislature's view of the statute.
Whether they think that or not, the ramifications of not doing something leads the interpretation of the correction law, parts of it to be
But I guess my point is they've
superfluous.
decided not to do anything. So we would say, despite you not doing anything, your statute, you know what it says, you're not doing anything, we know better.
Well, in this case, yes, because it's an unreasonable and absurd result. There's superfluity in the statute by not doing anything.
So you have an alternate argument, right, which is that the sexually violent designation is subject to a downward departure in the discretion of the court on a reading of the statute that I think is laid out reasonably well in Justice Renwick's dissent in Bullock. So if that is right, if Justice Renwick were right, that kind of wipes out your absurdity argument, no? Because then there's a mechanism in the statute to deal with what you're calling the absurd result.
It is the escape hatch of my argument, and that would be that...
It blows up your first argument, but it provides you a road on the second.
Correct. And, that's the beauty of alternate arguments, I suppose. And when you have this opportunity in designations, right, 1, 2, or 3, there's discretion to change that.
Is there discretion to change it when this designation is statutorily described? I mean, the discretion you're talking about is coming off the assessment report. Here, we're talking about a statutory definition of violent sexual offender. We're just free to disregard the statutory language in that context?
I think if you look at 168L, the board makes a risk level designation recommendation. Then 168N, the court is to apply the guidelines upon receipt of the recommendation, meaning there's discretion there.
Yeah, but the court is always bound by the statute, right?
It is
The
bound.
statute sets out how one would define this particular category. How can the court decide otherwise?
Well, it's applying the guidelines, just as it would in a
The
risk level
guidelines could
determination.
not be contrary to the statute. The fact of the matter is the statute supersedes everything else. The statute's what's controlling.
You
We
mean
can discretionarily depart from the guideline or from the recommendations that were created within the guidelines. We can't use our discretion to depart from the words of a statute, can we?
No, and I'm not saying that. I'm saying applying the guidelines. That is in the statute, the plain language of the statute. Applying the guidelines would allow a court, especially in a situation like this.
Well, what part of the guidelines would allow a court to ignore the statutory mandate?
There's, in the statute, it says the essential elements, or it says the felony. So here, the court is left with what do I
And
do
if that
in
was
this
contrary to
situation?
the statute, what do you think controls?
I'm sorry.
If it would, contrary to the statute, what controls?
If it's contrary, I'm sorry, I don't understand what you're...
Let's try it as a hypothetical. If the guidelines said something that was contrary to the language in the SORA, in the statute, SORA Act, right? What would control?
Well, I
A
suppose...
SORA judge has this conflict. What is a SORA judge to do?
I suppose in a typical situation, the statute, I think that's what you're trying to get me to say. But at the same time, the statute itself has ambiguity. It has these problems, these absurdities.
Is it really ambiguity, or is sort of these arguments just a backdoor way to say it's unconstitutional? An argument that's not preserved, but is the problem really that there may be an unconstitutionality to this part of the statute?
Absolutely, I believe that there is, and that that portion of the argument is not preserved. But at the same time, we have these other avenues for this court to go down, because even if in the future this statute is determined to be unconstitutional, that does not necessarily help Mr. Talluto.
Counsel, if we agree with you and we do what you are asking, would this case have to go back to the SOAR court?
It depends on which way the court went. If the court finds that there's discretion in finding a designation, then yes, because this particular trial court stated that it didn't have discretion. If the court determines that the essential elements is the only thing that applies, then no, the court...
But even so, let's say we go on the second ground, wasn't the ground for downward departure here that the SOAR court relied on the fact that the determination of the defendant as a sexually violent offender will be sufficient to protect the public, so the SOAR court departed from a 2 to a 1?
Yes, Your Honor, that's true, that is a good point. For that purpose, that would be fine if the court ruled in that way, and then the court could then look at what happens now that he's not a lifetime designation. I would agree with that.
Thank you, counsel.
Good afternoon. May it please the court, my name is Greg Oakes. I'm the district attorney for Oswego County. Your Honor, the people are asking you to affirm the decision from the Fourth Department. We believe it was correctly decided by the majority.
Well, you didn't support this at the SOAR court or at the appellate division. You agree that there's something absurd about this outcome, correct?
There is something askew about it, Your Honor, and its application to this particular defendant, it does seem unjust. And at the trial court level, we were looking at an equity issue, but really...
So why should the judiciary stamp an imprimatur on what even you think is unjust? That's what the majority below thought was unjust.
And that's exactly it. I mean, we made an equities argument at the trial court, but the trial court judge, I believe, was correct in looking at it, that the statute is what guides. And when the Fourth Department says that their hands are tied, counsel says this is an unreasonable or absurd outcome. There are plenty of statutes that result in absurd and unreasonable outcomes, or which we may deem personally to be unjust or inequitable, but we have to go by the statute and what the words say.
That may be so, but aren't you concerned that there is, as Judge Rivera intimated, an underlying constitutionality problem here? Granted, it's not a preserved challenge, but it's a pretty glaring problem, from my perspective, anyway.
Your Honor, I recognize that issue, and it's not the issue that's before this court. Really, as it was decided by the trial court and the appellate division below, it's simply a statutory construction issue. There may come a day when that argument has been preserved, when the Attorney General's office has been put on notice and it's properly before this court. In fact, I understand that there's a case in, I believe it's Canandaigua County, where that issue is being litigated at the county court level, and it may percolate and come up to this court.
I know, but DA Oaks, we have to wait and then people have to register for life. I mean, the practicalities here are severe. And you're saying we should turn a blind eye to that and wait for a case that's on all fours that we can decide?
Unfortunately, that's the way our system is set up, Your Honor. Again, there may be a constitutional issue, and when it's properly presented and when it's raised below and argued, again, this court can act, and again, it would then hopefully apply retroactively. So again, if it were deemed unconstitutional, that this petitioner would have relief at that point and could potentially repetition. I share some of those concerns. In preparing for this argument, I spoke with a colleague, and I'm prone to hypotheticals. And in watching the Supreme Court and its decision in Dobbs, this question came up of what would happen to other cases? Lawrence v. Texas. And I have family members and dear friends who are in the LGBTQ community. And should Lawrence fall, and they go to a southern state that all of a sudden says sodomy is illegal, it's registrable, they then have to come back to New York State and register, be designated a violent offender.
So let me
The
then get you to, I think I understand where you're going. Let me get you, though, to the alternate argument that I'm
Yes.
interested in. So when I read 168N sub 1, it says a determination,
Yeah.
right, that an offender is a sexual predator or a sexually violent offender, which is what we're dealing with here, shall be made by the sentencing court applying the guidelines established in subdivision 5 of section 168L of this article, which is exactly the same language that's used in subdivision 2, which is talking about the risk level determination. Those two things are then both described as determinations when you go through the rest of N. So when I read the words of the statute, I don't find a basis to distinguish between the discretion afforded the SORA court in downwardly departing on the risk level as compared to the designation. They read the same. It's the same set of words and the same set of guidelines, which I don't believe, I don't at least understand as the guidelines with the capital G promulgated by the board, but rather the list of factors that are enumerated in subsection L.
And Your Honor, as I look at that, again, I believe that the designation, whether they're a predator or whether they're violent, I don't believe the court has discretion because the terms of those and those specific definitions are set forth in the statute.
But why would it then say that the determination should be made by the court applying the guidelines established in subdivision 5 of section 168L? If it's determined statutorily, what do the guidelines have to do with it?
And I believe those guidelines apply to the risk level and where there's a downward departure or an
That's stated in
override.
subdivision 2, but it's also restated in subdivision 1, which regards the sexually violent offender designation.
Okay.
That's what it seems to me if there's discretion for one, there's discretion for the other, the way the statute is written.
Right. And I see how the court can reach that conclusion. Again, as I have read it, Your Honor,
Does that solve the equity problem here and solve it in a more general way, which is that in some ways, if there is a constitutional issue lurking here, interpreting the statute as Justice Renwick did in Bullock and as I'm suggesting now, saves it. Because it gives some discretion in a case like this where everybody seems to agree this isn't proper.
right. And I'm not sure it saves it on the constitutional issue, which, again, isn't here.
Right.
Again, it can render a particular case particularly more just, in that it does give the court discretion. Again, I generally believe in giving courts discretion so they can make fact-specific determinations based upon the equities of that case. However, as I do read the statute, Your Honor, I realize the parallels in those language, but I've read it as, the court does not have discretion in this aspect, only for the rating, for the departure and overrides. And again, when I talked about...
Well, it would leave it to the vagaries of an individual judge. Well, this judge might have been hospitable, another judge may not. And then you're going to have the disparate treatment between two people who may be absolutely
Similarly
placed
situated.
similarly.
Yep. And a few moments ago, when I talked about potential concerns on the constitutional issues, what my colleague reminded me, though, is, again, we are bound by the statutes, whether we personally agree with it, and we are trying to anticipate potential disparate treatment or unequal treatment. it is up for the legislature. There is a separation of powers that we as the executive branch, through the prosecution or judiciary, have to follow what the law says. Judge Singas, as you mentioned, the statute was amended in 99 to add in this provision, and then in 2002, there was language that was excised or removed out where it was talking about if there's a term of imprisonment of more than 1 year or where the death penalty applied. The legislature, after its initial enactment, revisited this statute and decided to leave that language in there, presumably making a conscious decision. Now, whether we agree or not,
What do you think, just clarify, I know you mentioned it in your brief, but just clarify for us today. What do you think animates that conscious decision from the legislature's side? Apart from inertia,
And I
right? It's on the
apologize.
long list, we'll get to it when we get to it. Not that, not that.
what animates the legislative decision, I really can't be sure, Your Honor. Again, it may be a conscious decision to say, we don't know what the laws are in other states. And through federalism, we have 50 laboratories across the United States, and in some sense, 62 laboratories within the state. And again, another state may be ahead of us on certain provisions of the law. For a long time, other states led us in having revenge porn statutes, where we didn't have that. And again, there may be an offense or something that occurs. Again, in the last 20 years since this was passed, we've seen all sorts of computer crimes, some of those unfortunately involving children, where other states are going to be ahead of us, where common sense would dictate those should be registrable, but our legislature just hasn't gotten there yet.
Do you know if any other state does what New York does in this section?
I don't, Your Honor. But, Judge Rivera, to get to your point, I don't know if the motivation in the legislature matters. As was mentioned, the commission out of this courts brought this issue to their attention. Bills have been submitted, and in the recent few years, we've had one-party control of the Assembly, Senate, and governorship, and yet that party hasn't acted on this. I would think consciously, and whether that's
I
out of
recall in the
principle.
briefs you did suggest, it might not be what actually motivated them, but a suggestion for why the statute might be written this way.
Well, and I think the reason why the statute's there is to be more encompassing, because we can't always anticipate other offenses. And I think part of it's also really trying to give respect to other states with the idea of recognizing that if somebody's committing an offense there, they shouldn't be able to escape punishment or registration in that state simply by coming across the border to New York.
Thank you, counsel.
Thank you, Your Honors.
Justice Rivera, you mentioned disparate treatment, and that's something that's already happening. There's, in the reply brief, I cited to a half dozen cases where an individual was convicted of an out-of-state crime that wasn't violent and was not designated violent. So it's already happening, and Mr. Talluto just happened to be unlucky with what judge he was given, and that's just not right. Whether it's to return the matter for discretion.
Counsel, is a crime that involves forcible compulsion a violent crime?
Your Honor, I would say this particular crime is not a violent crime, Mr. Talluto's,
But
and
the
all the
judge,
parties
where I'm
agree with
going
that.
is,
I-
the judge here found forcible compulsion, right? That's what got your client to a level 2.
And,
So
but
is
if-
this really the case to argue it's not a violent crime?
If that's the finding, then when we return it back, Judge Todd or whoever will make a determination whether a downward departure is appropriate, and that's the more appropriate way to do this, to not have a disparate treatment among defendants across the state. Thank you, Your Honor.
Thank you, counsel.